Hello and welcome back to another class on drafting, pleadings and appearances. In the previous session, we saw a brief overview of the entire syllabus and the subject, and we went ahead to understand certain concepts under a lesson number 2, that is general principles of drafting. Now, before continuing from where we left in the previous session, let's have a small quick recap or revision of what we discussed in the previous session. So now when I'm going to mention the points that we discussed in the previous class, you should be in a position to recall the points that we discussed. Only with that you will be able to go ahead with today's session. So we began to understand the previous session by seeing the brief overview of the subject. When we saw the overview of the subject, we saw certain important terminologies like what is the meaning of the term drafting, what is the meaning of the term pleadings, appearances and conveyancing. These terminologies lay the foundation for this entire particular subject. Once we saw the overview of the subject and understood the foundation itself of the subject, we tried to establish certain differences between the terminologies like what is drafting and the difference between conveyancing. Then we went ahead and saw the difference between conveyancing and contract. Once these basic concepts were discussed, we went ahead and saw certain important points under lesson number 2, that is nothing but the actual general principles of drafting. After covering all the general principles of drafting, we went ahead and discussed the additional rules of drafting. As laid down by Mr. Fowler, that are 5 rules that he has mentioned. Once we saw the additional rules, we understood the procedure of drafting, where the entire procedure of drafting is divided into multiple steps. We start by creating a sketch of the document, then go ahead and creating a skeleton draft and doing the self-appraisal by elaborating the points and creating a set of document, the entire draft of the document, and then getting it vetted from an expert to remove any kind of errors, deficiency or defects in the document, and thereby after all the steps are completed, we are going to finalize the document, which is going to be put into actual use at work. So this is what we discussed in the previous class. Now let's continue from where we left and go ahead with the remaining part of lesson number 2. Moving ahead, on the basis of what we discussed in the previous class, keeping in mind the general principles of drafting and the additional rules of drafting, we are going to sum up all the points that we saw in the previous class into certain basic principles. So now we are going to see the sum up of the principles that should be kept in mind while drafting. So the first principle is that the document as far as possible should be self-explanatory. What is the meaning of the word self-explanatory? Self-explanatory means the reader should not be in a position for looking out for any additional information or external source of information over and above or outside what is there in the document. Keeping a document itself should be sufficient for understanding what is there in that particular document. You should not be in a position where you are asking for any additional information or looking for other sources of information outside of that particular document. The intention of the draft person should be clearly communicated through the document. That is what it means. Now going ahead to the second principle, it says that the draftman should begin with satisfying himself first that he appreciates what he means to say in that particular document. So he should begin. So for having a good, well drafted document, it is very important for the draft person, the person who is going to draft the document, for himself to have a clarity about what are the contents of that particular document. If he himself is not satisfied about what he wants to communicate through the document or what are the points that he wants to include in the document, you can never have a good drafted or a clear cut or a document which is out of any kind of confusions. So it is very important to begin the process of drafting by the draft person himself having the clarity and satisfying himself of what are the points that I am going to include in that particular document. Going to the third point or the third principle, a well-drafted document should be clear to any person who has a competent knowledge of a subject matter. Very, very important. Why is this point important? Now, let's say that we are experts and somebody puts a document in front of us which is our domain. We are experts in that particular matter, and while reading that particular document, if we as experts only get confused, we as experts only don't have clarity about what is the content of that particular document, can we expect a person who is not an expert or a layman to understand the contents of that particular document? No. So to qualify as a good drafted document or to be considered as a good document, it is very important that at least the experts should have clarity of what is there in the document. If the expert level itself get confused about the contents of the document, definitely there is some kind of error in the language or the type of communication you're using for including the points in your particular document. So it is very important that the document should be well understood by the people who are experts in that particular field. If they have clarity, maybe even the layman will be able to understand what is there in that particular document. If the experts themselves are confused about what is the content, definitely the next people who are going to read, that is a person who does not have a knowledge about that particular subject, he will definitely be left confused with that particular document. So the principle says that you should ensure that the person who has competent knowledge with respect to that subject matter will have clarity after reading that particular document. Moving ahead to the next principle, the draft must be readily intelligible to a layman. So it is in continuation of what we discussed in the previous point. In the previous point, we laid down the foundation that if the expert understands with clarity what is the content, there are chances that a layman will also understand the content. If the expert himself is confused with what is there in the document, definitely the layman will not be in a position to understand the contents of that particular document. So once the expert has given that, okay, this document is clear, whatever you're trying to communicate is clearly included in the document, then we are going to pass it on to the people who are going to actually use that particular document. And any person, randomly any person who reads the document, he should be in a position to understand that particular document. Need not that he should have full knowledge about it, but what is mentioned in the document, he should be able to understand. So for this, the kind of language that we are going to use should be appropriate. You should not use terminologies which are so complex that you have to look in for the meaning in dictionaries to identify what is the meaning or to have the understanding of technical terms. So as far as possible, the language that we are going to use should be in a form that it can be easily understood by any layman. Moving to the next principle of drafting, the document will not be perfect if you are trying to say too much in a document, if you are trying to convey only certain points and letting go of certain other important aspects, or there is any kind of ambiguity or confusion with respect to the contents of your particular document. So for having a perfect, well-balanced document, you should know the facts exactly, you should know the law exactly, and only then you will be able to balance and make a good drafted document. If you are putting too much information which is irrelevant, it is going to increase the length of the document, which is totally irrelevant. So only relevant points should be included. Saying too little, you have to give material facts, material information in the document, and if you are going to let go of those material information, the document itself is not going to be complete, and an incomplete document can never be perfect. Or you are going to create ambiguity or confusion with respect to the facts of the case itself. So the draft person himself should first be satisfied and fully acquainted with the facts of that particular case. So it is very important that we should avoid all these points. We should avoid giving too much information, we should avoid giving too little information, we should avoid having any kind of confusion or ambiguity with respect to the facts of a particular case. Moving ahead, This is also in a link to what we discussed in the previous point itself. It says nothing is to be omitted or nothing should be admitted at random in the document, that is, negative statements should generally be avoided. So they are saying that the negative statements should generally be avoided. You should not omit something that is relevant or irrelevant or material for understanding or creating that entire document. Neither should you add or admit any point that is not necessary for that particular document. As such, negative statements should be avoided. As far as possible, positive statements should be used. Moving to the next principle, use of juridical language should be made. What does that mean? It means that as far as possible, we should use a professional language. We should use legal language. When I say legal language, I don't mean to say the legal terminologies as such, but the language that we are going to use cannot be spoken English. There is a difference between spoken English and written English. So whenever you're going to draft a document, you cannot use general spoken English. You have to use professional English language for the purpose of drafting or writing, and that should be kept in mind by the draft person. So the language that you're going to use is very, very important to have a well drafted legal document. Going ahead, the text of the document should be divided into various paragraphs and various points. As far as possible, we should avoid writing long paragraphs. We should avoid writing long sentences. You should keep the document brief, concise and easy to understand. If you somebody gives you a one-pager document of A4 size sheet with full text in one paragraph, will you even have an inclination of reading that particular document? Your brain automatically is going to send signals that what is it? Okay, should you read it? Should you read such a long document or not? On the other hand, if somebody gives you a same A4 size sheet with the same content but given it point wise, with shorter sentences, with gap between important points, it is going to be attractive. It is going to make the reader inclined towards reading that particular document. So as far as possible, we should avoid using long paragraphs. We should put it in point as much as possible, and we should keep our sentences also short. Each paragraph should be self-explanatory. The link between one paragraph, second paragraph should be properly established. The para itself should be able to be explained what it wants to explain through the terminologies or the language used. Plus, the most important thing is important marking. The numbers of the clause, the numbers of the subclause, number of paragraph is very, very important. Whenever you see any enactment, even an enactment is a document that is drafted, whether it is the Companies Act, whether it is the SEBI regulations, whether it is the Partnership Act, any enactment that you see, it is also a legal document. And you can clearly understand how they have drafted. They give you the chapter number. After the chapter, they give you the section number. Under the section, there are subsections. Under that, you have clause. Under that, you have subclause. So you can write it as, if you are seeing generally the definition clause, that is section 2. Section 2, subsection 1, clause A, subclause 2. So easily every aspect of it should be properly marked and properly numbered so that you can easily refer to that particular clause when required. Next. Schedule should be provided in the documents. Very, very important. In the previous session also we saw the requirement of schedules. Why we include schedules? To make the document concise. Specifically when we discussed in the previous class, we saw the aspects of sale agreement, where in the sale agreement we were selling a particular property, the details of the property had to be provided. And we saw in the general principles that whenever we are going to describe a person or describe a property, the complete details should be provided. When I say complete details, the details of the property with respect to its address, that is where is the property situated, what is the measurement of that particular property, what is situated on its west, north, east, south. All these details should be described, and at every time when you are going to describe the property, you cannot give so many details of the property. So we are going to just say that Mr. A is going to sell the property to Mr. B as may be described in the schedule. So you're just going to see the schedule, and in the schedule we would have given the complete description of that particular property. So wherever possible, you should try to include schedules in the document to avoid elongated documents or extremely lengthy documents. Now moving ahead, let's understand what is the importance of keeping schedules. It explains useful matters, which is a very important part of a document. So whenever we are going to add annexures or schedules to a document, you cannot say that this is not a part of the document. The document includes the schedules, includes the annexures that are attached to it. So it helps in giving out certain important information through schedules. Next, it should not be ignored. If a document is given, you cannot read the document and say, I'm not going to read the schedule. Similarly, what we have in the Companies Act, right? You have schedules. You have schedule 7. In the constitution also we have schedules, where we have a schedule which says what is union list, what is concurrent list, and what is the state list. That gives the topic for discussion of which authority has the power to make laws on what particular topic, whether it is the central government, state government, or concurrently both the state and center. So until and unless you don't understand or don't read through the schedule, you will not know which government has what power. So you cannot say that I'm not going to read the schedule, I'll read the other remaining parts of the document and that is sufficient for me. To understand 100% the content of a document, you should read through even the annexures, even the schedules. So at no point in time, the schedules should be ignored by the person who is reading a particular document. It should not be inserted in the body of the document. Very, very important. Why are we giving a schedule? Because we want to communicate certain information which may be repetitive in nature and which is lengthy, which need not be included in the main body of the document. So we are going to put it at the end of the document by calling it as a schedule or calling it as an annexure. So it should not be included. Schedule should always be towards the end of the document and not as the main content or body of that particular document. So these are the points you should keep in mind with respect to schedules. Now, what is the actual purpose of creating schedules? It is going to be supplementary in nature, where it is going to give some kind of clarity and convenience to the reader. We are going to get clarity about what are we going to talk about in the main document, plus convenience is as in when you require to see the schedule, we can swap the pages. You know the schedule is always at the end of the document. So you can swap the pages and directly go to the schedule and see what is the content that you have to read. So it is convenient, plus also it brings clarity to the entire document. So this is the importance of schedule in a particular document. Coming to the next principle, it says that the active voice is preferred over a passive voice. So since you're all in CS professional program, I like to believe and assume that you all know the basic principles of English of what is an active voice and what is a passive voice. So they clearly say that whenever we are going to draft a legal document, we should ensure that we are using the passive voice, we are using the active voice and not the passive voice. We can use, okay, so general rule is prefer active. As much as possible, you should use active voice, but there are certain situations that you cannot let go. You have to mandatorily use the passive voice for what? For clear meaning, for communicating the content more clearly, more precisely. There are situations where you will be required to use the passive voice. They are totally not prohibiting the use of passive voice. They are merely saying that if you have a choice, go with active voice, but if required for clearly communicating your content, if there is a requirement for using the passive voice, you can go ahead and use the passive voice. So let's take a quick example for active voice and passive voice. Let's assume if I say Mr. A has paid an advance of rupees 50,000, it is an active voice. On the other hand, if I say advance has been paid, advance of rupees 50,000 has been paid, then it is going to become a passive voice. So, as far as possible, we should try to use active voice over passive voice. Similarly, if you want to take one more example, we can say that injunction was granted by the court. You can the same thing can also be communicated like court has granted an injunction. So, the language or the communication is same. What we are trying to communicate, both the sentences are communicating the same thing. So, they are saying that as far as possible, try to use the active voice over the passive voice. But there are situations where mandatorily you will be required to use the passive voice. In that case, you can use the passive voice. There is no prohibition as such. Going to the next point. Okay, so those were the general principles summing up all that we have seen in the previous class. Now, let's go to something further and see what are the do's while drafting, what you should actually do while you're drafting a legal document. First and foremost is reduce the group of words to a single word. This we had also covered in the previous class, where they are saying as far as possible, where you can use a single word rather than writing a long sentence or a group of words. Let's take an example. If we have to say that any action of breaking the law or breaching the terms of contract or breaching the terms and conditions will lead to punishment. This is such a long sentence. Group of words are used to communicate a particular meaning. Now, same thing can also be written as infringement of provisions will lead to punishment. Same thing, the meaning is same. The outcome of the wordings is the same. It is just that one single word infringement can replace n number of words that are used to create that particular sentence. So, as far as possible, if you can use one word to communicate a longer sentence, you should prefer that one word over a longer sentence. Next, use simple verb for a group of words. What is verb? All of us know. Right? We know what is a verb. So, as far as possible, we should use verb for a group of words. For example, like if you are using legal language, you can use the word as bona fide. That is in good faith. Per se. Prima facie, on the face of it. Right? So, as far as possible, try to use verbs instead of using group of words. So, you should use single words and shorter words as compared to longer sentences and a group of words. Next. Avoid roundabout construction. Avoid roundabout construction. They mean to say mention or include all the points directly. Be clear cut. Be crisp in what you're writing. You don't have to go about running the bush. You don't have to complicate it. Directly, whatever you want to communicate, do it directly. There is no need to bring any kind of indirect reference in your documentation. As far as possible, keep it clear, crisp and direct to the point that is required to be addressed. There is no need to running about the bush for explaining a particular concept. Avoid unnecessary repetition. All of you will be used to repeating. If there is a 8-mark question that has been given in your question paper, what are you going to do? You know only certain aspects, you know only 5 or 6 points that you have to write for 8-mark answer. What are you going to do? Same sentence, you are going to put it in different language and write it again and again. That is what you do for lengthening the answer. We have seen many answer papers where students do that. You just use different language to communicate the same point multiple times in the same answer. So you should not do that when you're doing a legal documentation drafting. You should keep it as short as possible. So that is why we should always clear that there should be no repetition of the clauses, no repetition of the content that you're going to put in the document. As far as possible, keep it limited, keep it crisp, keep it short, keep it concise. If you're going to repeat the same clauses again and again, it can lead to confusion, it can lead to ambiguity, it can lead to lengthening of the document, which is not the ultimate objective. So as far as possible, we should avoid repeating the sentences or statements or clauses that you want to include in your legal document. Next. Write shorter sentences, because our ultimate objective is that we only want to communicate certain things through the document. That can be done by using single words, that can be used by using verbs over a group of words. You can use that by using shorter sentences. So that is what they are saying here, that avoid repetition, avoid long paragraphs. For that, what you should do is write shorter sentences. If you write shorter sentences, automatically the other objectives of drafting will be achieved. Next, express the ideas in a fewer words. It is similar to what is the previous point, write shorter sentences. Shorter sentences can be written only if you are using lesser words, and that is exactly what they are telling here, that as far as possible, all the ideas should be expressed by using lesser words, fewer words, rather than giving long sentences using n number of words. Try to use short words, try to use single words to explain your concept. Next, prefer active to passive voice sentences. We have already discussed this in the previous general principles. The same thing they are telling, as far as possible, you should use the active voice rather than the passive voice. Choose the right word. Terminology is extremely important. The same meaning can be derived out of n number of words, n number of sentences that you're going to form. So as far as possible, the word that you're going to use, it should be appropriate in that particular document. You should go through the legal dictionaries, you should go to the general English dictionaries when you're going to draft legal documents, because the wording in the sense that you're going to include in the document, the same should also be communicated to the reader. So the use of terminologies, the use of words should be appropriate to communicate your intention. Next one. Know exactly the meaning of the words and sentences that you are writing. If you yourself don't know the meaning of that particular word, how can you incorporate that word in a particular sentence? If you have a confusion with respect to the meaning of a particular word, don't include that word, or get a clarity, refer the dictionary. After you have got the clarity, then use it in your words, then use it in your particular document. So until the draft person does not know the meaning of a particular word, he should not use it in his document. He might think that this is the meaning of it. Maybe that is not the meaning. Maybe after including that particular word in the document, it will mean something else once we finally read the document. So as far as possible, you should use only those words and terminologies of which you are aware, the meaning of which you know perfectly. If you want to use a word, you're not sure about the meaning, go view the dictionary, refer the dictionary, be satisfied of what is the meaning, and then decide whether it is suitable to be included in that particular clause or not. So as far as possible, the draft person should know the meaning of the words and the sentences that they are going to include in the draft. Next. Before putting an end to drafting, once you finally drafted the document, you should put yourself in the place of the reader. Forget that you have drafted the document. Now make a clear-cut distinction that I was earlier draftman, okay, over. Now somebody has given you the document to read. You are going to read it and see whether you can understand it or not. Right? So you should put yourself into the shoe of the reader and read the document first. Then satisfy yourself about the content, the interpretation and the sense that it is going to carry to the reader. As the draft person, you have drafted the document and put an end to it. But when you are going to read it, is the same thing being put across as to the reader also? What the draft person is trying to communicate, is that being communicated to the ultimate reader that should be satisfied before finalizing a document. So once we have drafted, we should go through it, we should become the reader, we should get into the shoes of the reader, read the document for ourselves and see about, first read the document and then satisfy about the content, whether what is being mentioned, what clauses are there that are perfect or there is any kind of change that is required. Is there any kind of ambiguity or any interpretation that can be brought about with respect to the language that you've used? And ultimately, is the intention of the draftman also communicated to the ultimate reader? These are the things that you should do while you are drafting or once you have completed your drafting. Moving ahead, don'ts. What should you avoid? What you should try not to do while drafting any legal document? First and foremost is avoid the use of words of same sound. What does this mean? For example, whenever we draft agreement, let's say an employment agreement, we use the terminologies like employer, employee. There are chances of errors when you're using similar sounding words. But generally in the domain, in practice, this is how drafting used to be done. But now over a period of time, this concept has changed. We try to avoid using the words that are similar. Instead, we use now the company. And we use the word employee. As far as possible, similar words should not be used to describe two parties. Similarly, even when you are drafting an agreement for lease, lessor and lessee, similar terminologies. So, similar terminologies as far as possible should be avoided in the documentation. Next. When the clause in the document is numbered, okay, like I told you, as far as possible, we saw that when we are drafting the document, it should be paragraphed, small paragraphs, it should be point wise, the point should be properly numbered, sequential, clause number, subclause number, all that should be properly marked and numbered. So whenever you are going to have a numbered document, properly having numbers for your paragraphs and points, it is very convenient for us to refer to any one clause by using that single number for using it. So that is what they are here. Rather than don't do it while drafting, they are trying to say that as far as possible, you should do what? You should include properly marked numbers, marked points or marked paragraphs. For example, if we want to say that we have mentioned point 1, 2, 3, 4, etc. In point number 3, we have to refer to the previous point that we have mentioned under point number 2. So instead of writing the entire point number 2 again, you can simply say in clause 2 above, as mentioned under clause 2 above, point 3 subjected to what we have mentioned under point 2. So when you have mentioned proper numbers and given proper points to your numbers to your points, it becomes easy for reference, it becomes easy and convenient for referring as well. And this is what you should actually practice. So you should avoid what? Avoid keeping longer sentences and avoid keeping unmarked sentences or points. Next. Negative in successive phrases will be very carefully employed. As far as possible, we should use positive sentences rather than using the words no, cannot or should not or will not. Okay, wherever the use of the word no or not should not be encouraged as such. Okay, if you want to include any kind of restriction, you say, let's say, instead of saying that the person who is taking the house on rent, we call that person as a tenant. Tenant should not use the garage. This is a negative sentence. Rather than, you can say that there is a restriction on the tenant with respect to so and so. As far as possible, keep the document positive in nature rather than keeping it negative. Rather than saying no, should not, try to construct the sentence in such a way that the same meaning is conveyed, but it is in a positive sense. Negativity should not be there, or negative words of use like negative words is no, cannot, no, or all those terminologies should be avoided in legal documentation. You have to communicate. There will be restrictions when you are drafting the legal documents, but you should not keep the negative elements or negative language. You can construct the sentence in a positive way as well, and the positive aspect or positive sentence framing should be utilized. Next, the draftman should avoid the use of the words like less than, more than. Okay, instead of that, we can use the words like not exceeding a particular amount, not exceeding a particular limit as may be specified. So, the terminologies or language that we are using should be professional, should be up to certain standards. You cannot use the general English spoken in your day-to-day activities. So, there should be some kind of professionalism that is going to be maintained while drafting legal documents, and that should be maintained. That standard should be maintained in your legal documentation. Next. When 2-3 clauses are there, clause 1, clause 2, there are situations that for, let's say, for eligibility itself, you are discussing some kind of eligibility, whether a particular person is eligible or not. So, in that, n number of conditions are there. So, in that case, whether you have to say both points, okay, so you will say either point 1 or point 2, nor neither 1 nor 2 is satisfied. So, whenever you are going to use the words, okay, when you have to communicate about two different clauses applicability, the use of appropriate words should be kept in mind. What are they saying? That the draftman has provided for each of the two positions that are going to happen without each other. Without each other means either 1 or 2. If even 1 is there, we are happy with it. We are, the eligibility is satisfied. Either means any one of the situation occurs, it is eligible. That is, either will not be sufficient, and he should write either or both, right? If you want both the conditions should be satisfied, we will write both. If we don't want anything, we are going to use the word nor. So, whenever specifically talking about eligibility, the use of words that you are going to make use of, you should be very careful. Next. So, with that, we have come to an end on what you should do, what you should avoid while drafting. Moving ahead to the last concept for today's session, we are going to see how you should give special attention to certain aspects, like when you are typing and or. Again, this is very, very important. These are the mistakes that you should avoid while drafting a legal document. Specifically, let's talk about if you have already come across, because you are CS professional students, you would have already come across subject, securities, laws and capital market. In that, we know that n number of conditions are applicable if a company wants to go for an initial public offer or a further public offer. N number of conditions are there, and when we are going to see the conditions, we should see whether each and every condition is required to be fulfilled, or even if one of the conditions is satisfied, we can go ahead and do it. So, when we say point number 1 and point number 2 and point number 3 and point number 4, that means each one of the 4 conditions should be satisfied if you want to make an initial public offer. On the other hand, if we write point 1 or point 2 or point 3, that means even if one of these conditions is satisfied, we will be eligible for making the initial public offer. So when you should use the word and, when you should use the word or is very, very significant. Even one error in your typing mistake or one error in the use of terminologies can convey entirely different meaning to the reader of that document. So where actually eligibility requires all the conditions to be satisfied, but if you have not included the word and, if you have omitted the word and, the reader will think that any one of the condition, if we are satisfied, we are going to be eligible for making the IP, but actually that is not the scenario. You have to fulfill each one of those points. So whenever you are using, specifically this comes in eligibility criteria, so whenever you are using the terminologies like and or, you should be very careful while using these terminologies. Next, any and my. Okay, generally these are the typing mistakes that can happen when you are quickly typing something. So whenever you are typing, proofreading is very important. Proofreading from the point of view of grammatical mistakes and spelling mistakes. Obviously, now we have a lot of high-end technology where automatically the document or the software itself pops out what the sentence is grammatically wrong or the spelling that you have used is wrong. So automatically you will get to know that something is wrong. But earlier days that was not available. So we had to proofread the document again to verify whether the typing is correct, spellings is correct, grammatically the sentence makes sense. So all these things should be kept in mind when we are going to draft any legal document. Even if high-end technology is there, at times it suggests wrong grammar. It suggests we are trying to communicate something, but it understands in a different way because it is again a machine, right? So for that, even if a document has been proofreaded technologically saying that there is no error in the document said everything is grammatically correct, everything, all the spellings are correct, you should still manually once read through the document, do the proofreading to identify there is no typing error with respect to spellings, grammar or any other kind of errors or defects. Next, no and now. No and now. No means do you have the knowledge about it. Now is present situation. So generally while tapping these errors take place and you should avoid these kind of mistakes. They have just quoted certain mistakes that is going to be made and you can go through. As far as possible we should use present tense, past tense should be avoided. Okay. Present and past tense, you should be very careful. If you have started the documentation using present tense, you should complete the document using the present tense. Half of the sentences cannot be in present tense, half of the sentences cannot be in past tense. So whenever you are structuring a document, you should make sure in what language you are using. Firstly, whether it is passive or active, whether it is past tense or present tense. Once you are sure about that, once you have decided something, the entire document should be of the same voice and should be of the same tense. You cannot mix up the sentences that you are going to do half in present tense, half in past tense. That is not going to be appropriate for legal documentation. Next. When we are going to use certain specific words and phrases, what are the guidelines that you should keep in mind? First and foremost is there cannot be a clear-cut rule for telling what word should be used or what phrases should be used. We can only give you guidelines, but clear-cut distinction cannot be made that for this thing only this word should be used, because the vocabulary is so vast and every individual has different level of vocabulary. Somebody is beginner, somebody is an expert in the language. So the kind of words they know, the kind of vocabulary knowledge they have is different for every individual. So you cannot actually give a clear-cut distinction or guideline of these are the words that you are required to use in legal documentation. That is not possible, but for that we can just give you basic guidelines that you should follow. That is, first and foremost is whenever you are going to use any kind of word in your document, we saw in the general principle also the draft person should know the meaning of that particular word. If you have a confusion with respect to the meaning of a particular terminology or a word, what you should do is actually go and refer the dictionary. If it is a general word, general English word, if you have an ambiguity of understanding the meaning of that particular word, you don't know the meaning of that particular word, go and refer the general dictionary like Oxford, Webster, any standard dictionary, English dictionary. You can refer, understand the meaning, and then decide whether you want to include that particular word in your document or not. Moving ahead, if you're going to use any kind of legal word, legal terminology, then you have to refer the legal dictionary. Like we have the basic English dictionary, for English terminologies we have the legal dictionary, right? For the legal terminologies we have the legal dictionary. Some is like Wharton's lexicon. In India we have Mitra's legal. All these legal dictionaries are required to be referred to while you are trying to understand the meaning of a legal word. And until and unless you are not sure about the meaning of a word, you are not allowed to use that particular word in your draft. If there is any confusion, refer to the general dictionary, refer to the legal dictionary, identify its meaning, identify whether it is suitable to be included in that particular clause in that particular document, and only then use it in your particular document. Next. Moving ahead, as far as possible, current meaning of the words should be used. We are going to use a particular word in a particular sense, but over a period of time, the language changes, the usage changes, so the meaning automatically will become loose, or some other meaning is derived with that particular word. Over a period of time, this happens with language, right? Now we all call Gen Z languages there, so for different generations, different languages they have. So with respect to that only, how we are going to start, how a particular word meant in a particular situation, it might be different over a period of time. So what is the meaning of that particular word in today's scenario, that should be kept in mind while drafting. You cannot use the word which is outdated, which has no significance, or which does not communicate the same meaning as on in today's situation. So as far as possible, current meaning of the word should be used while drafting legal documents. Whenever you are going to use the technical words, okay, you should use the technical words only after fully ascertaining what is their meaning, what is the sense of that particular word, whether it is required to be included or not, what is the special meaning, and reference can be given for that particular context. Now, you as company secretaries will also have to deal with certain aspects of intellectual property rights. Let's say you have to draw or draft an agreement for assignment of a patent, or assignment of your trademark, or assignment of any copyright. In that, you are going to use technical terms. If you yourself don't know the technical terms, let's say for example patent itself is going to be technological oriented. In that, legal terminologies will be there. Until you yourself don't know what are the terminologies, how will you be able to incorporate that into the assignment deed? It is not possible. So wherever technical terms are there, whether it is legal words or technologically oriented words, for your client when you are drafting the documents, you should be thorough with the meaning of that particular word and only then include it in your particular draft. Next. The most important, like I've always told even in the previous class, that the intention of the draft person should be communicated exactly in the same way also to the reader, and for that the choice of words that you're going to make, the choice of phrases that you're going to make should be proper. It should be accurate, it should be appropriate, so that the message that has to be communicated by the draftman, the same thing is also conveyed, the same intention is conveyed to the reader of the document. So the use of appropriate words and phrases is very important for communicating the intention. Lastly, when you're coming to read a legal document, there are chances and there are scope for interpretation. All of you have already studied the subject jurisprudence in GIGL, interpretation and general laws. In that you have seen the general rules of interpretation. If there is any ambiguity, if any point is unaddressed, how are we going to interpret that particular document? So that is why we have certain books on interpretation, and if you are going to use a particular word, you want to see how it has been interpreted in the courts of law previously, you can refer the books on interpretation where they have clearly explained of the use of the words in a legal document. As far as possible, if you should kind of bring clarity in your document, but if there is any kind of unambiguity, you are not sure about it of how this particular word will be perceived in the document, there are books on interpretation. You can see whether that particular word is already interpreted in a certain way by the experts, and then you can use it, see it, refer it, and then include it in your particular document. So these are the basic rules for interpretation as laid down under this particular chapter. Plus, by this we are going to sum up all the basic guidelines, principles, rules for drafting of legal documents. Next, we are going to see some other important concepts like what are the components of a legal document, specifically with respect to components of deeds, which we are going to continue in the next class. Till I see you again, take care and prepare well for your exams.